Registrar General, Supreme Court of Bangladesh, and Chairman, Minimum Wages Board. And Dr. Jamila A. Chaudhary, Professor, Faculty of Law, University of Dhaka. Welcome to this session. Thank you for being with us. In this session, we will have 4 papers presented by the participants. Mr. Bharat Kumar Rohalan from Department of Law, Amity Law University, Jaipur, India, will present his paper on rule of law and pandemic in India. Ms. Fatima Alam Oishi and Ms. Faria Tasnim Mitu, both are students of 3rd year, Department of Law and Human Rights of the University of Asia Pacific, will present their papers on international law and COVID-19. Mr. Muhammad Pavel Sarkar, who has completed his LLB honors and LLM from Southeast University, will present his paper on unprecedented challenges and possibilities in ensuring quality of higher education, the redundant impact of COVID-19 on the backbone of Bangladesh. And lastly, but not the least, of course, Mr. Ali Mashraf and Mr. Jalaluddin Ahmed, both are LLM students at the Faculty of Law, University of Dhaka. They will present their paper on operation of virtual courts, impact of COVID-19 pandemic on access to justice in Bangladesh. I will request all our paper presenters to keep their cameras on and also stay standby so that if we lose connection with one of our participants, we can accommodate the another participant. This session will be moderated by Mr. Muhammad Saleh Akram, Assistant Professor, Department of Law and Human Rights, University of Asia Pacific. I will now request Mr. Akram to take the floor and start the session. Good luck to the participants and thank you.
Good afternoon, everyone. Thanks to Alida Madam for giving me the floor. Greetings and thanks to all of you for attending the second session of the second day of this virtual international conference. The whole world has been going through a difficult time for more than a year. In this short span of time, people of all ages around the world have changed their long-term habits and have become accustomed to COVID-19 pandemic coping habits. This global epidemic situation has given us new challenges in various fields, including labor market, education, and justice, but hopefully people have found a way out of it despite so many adversities. I hope our young researchers will show us the way of life through their research and our path will be easy. Alita Madam said at the beginning that in this session, 6 participants will going to enlighten us through their 4 paper presentations. We are truly delighted that today we have among with us to give feedbacks and comments on the presented papers, Mr. Iqtedar Ahmed, former Registrar General, Supreme Court of Bangladesh and Chairman, Minimum Wages Board, and Dr. Jamila A. Chaudhary, Professor, Faculty of Law, University of Dhaka as distinguished panelist. Good afternoon, sir. Good afternoon, madam. Let me tell you the rules first. Participants will present their papers first. I kindly request the participants, please finish the presentation within maximum 20 minutes. Distinguished panelists will then discuss on the papers. My humble and polite request to the panelists that you will have 20 minutes to discuss. There will be a question and answering sessions at the end of it all. Now, we are going to start the paper presentation. With the permission of the panelists, I would like to invite Fatima Alam Oishi and Faria Tasnim Mitu, Department of Law and Human Rights, University of Asia Pacific, to present their paper on international law and COVID-19. Fatima Alam Oishi and Faria Tasnim Mitu.
Good morning, good afternoon, everyone. Am I audible?
Yes, you are audible.
Thank you, sir. Yes, I will be presenting some slides on international law and COVID-19. May I share the screen? Honorable panel of juries, sagacious dignitaries, lovely audience, a warm welcome to everyone. I'm Patimala Moishi, the author of the paper International Law and COVID-19 with my co-author Parihatasnim Nitu. I'll be taking the next 20 minutes presenting the different aspects of international laws which are connected with COVID-19. Jill Stein stated, I think we have a very critical role to play within the spectrum of international law and human rights. One might wonder how international law is connected with COVID-19. International law is a set of rules, norms, and standards which is bound by treaty, convention, agreement, and declarations. On the other hand, COVID-19 is a disease caused by a strain of coronavirus. It is the virus which has affected the world globally since March 2019. Approximately 176 million people are affected globally, and 3.79 million people have died due to this trend of corona. Coming to the main point of this research paper, that is the relation between this coronavirus and international law. Does it exist? The answer is yes, it does, and the range of international legal issues raised by the pandemic can be seen. In this multi-part series, we'll look at how COVID-19 is putting international laws, rules, and norms to the test. We'll concentrate on 4 international legal issues raised by the pandemic. 1. World Health Organization, International Refugee Law, International Humanitarian Law, and International Human Rights Law. Now coming to the first point, that is the World Health Organization and COVID-19. The World Health Organization is a part of the UN's health agency and has played a crucial role in tackling the COVID-19 pandemic ever since the first cases were identified in the Chinese city of Wuhan in December. World Health Organization is binded upon 196 countries where they aim to prevent, protect against the international spread of disease. Article 2 of the International Health Regulation states that the aim, purpose, and scope of this regulation are to prevent, protect against, control public health response to the worldwide disease, and avoid unnecessary interference with international traffic and trade. Approaching to the actions taken by World Health Organization during COVID-19, they are: the health agency work closely with governments to ensure that informations are correct and helpful and from trusted resources. It also works with International Chamber of Commerce and other private sectors to ramp up the production and distribution of essential medical supplies. World Health Organization also launched an UN COVID-19 supply chain task force which increased the supply of essential protective equipments, and it also sent emergency medical teams in emergency zones. Despite the actions taken by World Health Organization, due to their prior actions, many states had to violate international health regulation. It was seen that the World Health Organization has been proven too ineffective in response to the pandemic and was laid back in the initial phase of COVID-19, which was seen as playing a critical role for the rest of the world. History has already witnessed a few pandemics similar to COVID-19, such as SARS, Spanish flu, or Black Plague. During the Ebola outbreak, international health regulation aimed to prevent and control the disease international spread while avoiding unnecessary travel restriction. The World Health Organization did the same in the starting of COVID-19. Unlike WHO's guidance of not closing down the border by the end of the March, almost every country enforced mandatory international travel restrictions. Well, under international law, it does give the nation the sovereignty to implement their additional health measure. For example, on Article 43 of the International Health Regulation, it explicitly leaves space for actions that goes beyond that suggested by World Health Organization, which is consistent with respect for the sovereign right of the states. Article 2, Clause 1 of the Charter of the United Nations also addresses all countries' sovereign equality. Article 4, Clause 1, Subclause 3 of the International Covenant on Civil and Political Rights states, in time of public emergency, which threatens the life of the nation and the existence of which is officially proclaimed, the state parties, to the degree strictly necessary by the circumstance, may take measures derogating from the responsibilities under the present covenant. States' violation in travel restriction can be included as the sovereignty, but in the other factor where governments may have violated IHR by neglecting to collaborate in the fight against COVID-19. State must collaborate to the maximum possible by coordinating medical, logistical, financial, and legal responses to public health emergencies according to the regulations. Many countries may have breached it in the early months of the pandemic when they closed their borders, hoarded medical supplies and personal protective equipment, and blamed each other for the disease spread. The scope of those issues are the real negligence of international law. Coming to the next point, due to COVID-19, the governments around the world delegated its power in many ways towards international law, and one of them is international refugee laws. The global pandemic has stopped asylum seekers in their tracks as states across the world have sealed their border, suspended asylum procedures, and in some cases, summarily deported asylum seekers. Some of these measures have been explicitly justified using public health emergency laws. Others have been implemented quietly and informally behind the scene. As a result, it has been almost impossible for most asylum seekers to travel to access protection. COVID-19 has precipitated existing trends towards the end of the right to seek asylum in Australia, Europe, the United States, and Canada. As a result, for the first time, perhaps since the construction of the modern international refugee regime, the early months of 2020 saw an effective extinguishment of the right to seek asylum. Article 14 of the Universal Declaration of Human Rights sets out an individual right to seek and enjoy protection from persecution, supporting the 1951 Convention relating to the status of refugees. The fundamental principle of this law is principle of non-refoulement under Article 33, Clause 1 of the 1951 Refugee Convention, where the non-refoulement duty is binding on all organs of a state party and any other individual acting on its behalf. The principle of non-refoulement, which is the cornerstone of international jurisprudence, has developed and become a customary international law and steadily attained a jus cogens status. But in recent times, during COVID-19, states have violated the principle of non-refoulement by closing down the borders as well as putting a stoppage to all kinds of asylum seekers. According to the United Nations High Commissioner for Refugees, 167 nations have fully closed their borders, and 57 of them made no exception for persons seeking asylum. The main reason for me to bring this law in light of COVID-19 is that the government could have taken protective measures and maintained the principle of non-refoulement. They do not have the authority under international law to entirely ban asylum seekers from entering the country. According to the Article 14 of the UDHR, it states everyone has the right to seek and enjoy asylum from persecution in other countries. To save the right to seek asylum, state must lead by example by themselves, respecting that right. Moreover, abandoning the right to seek asylum in the developed world runs the real risk of invasion in the global south, where 85% of the world's refugees reside. Indeed, destination states should look to the example set by countries such as Colombia, Lebanon, and Uganda, which keep their border open to far more asylum seekers. The implementation of international law in state practice requires leadership. State must set an example to convince other states to adhere to protection norms. Now, coming to my next international law and COVID-19, international humanitarian law. As COVID-19 spread unchecked in war-torn areas around the world, the international humanitarian law's principle of humanitarian access has become more urgent than ever. Local health systems, already overburdened by years of wars, are poorly equipped to deal with the new challenges posed by COVID-19. International humanitarian law provides a framework for ensuring the protection and respect of healthcare institutions, medical workers, medical vehicles, and the wounded and sick. The International Court of Justice determined in Israeli case of Wall Advisory Opinion that Israel's erection of separation barrier between the West Bank and Israel restricts access to health service and thus violate the ICESCR Article 12 right to health. Another example can be seen in Syria, where aid groups have encountered difficulties and interference in maintaining humanitarian access to a suffering population. The Security Council prevented aid workers from preparing for an outbreak of COVID-19 in northeast Syria, and since then, the situation has deteriorated, where northwest Syria witnessed a tenfold increase in COVID-19 cases. These are just a few examples of conflicts in which various actors have blocked humanitarian access. As aid agencies continue their effort to prevent the further spread of the novel coronavirus in this context, they will undoubtedly identify more examples where armed actors constantly impede humanitarian access. The International Committee for the Red Cross is the international humanitarian law database of customary international law, where the ICRC has a mandate not only to carry out relief operation, but also the primary obligation is to care for the wounded and seek without adverse distinction. If the states are unable or unwilling to fulfill their primary responsibility, they may not deny consent to humanitarian agencies that offer assistance. States are not relieved of these obligations during a pandemic. International humanitarian law clearly establishes that aid organizations, as the ICRC, have the right to offer aid in both international armed conflict and non-international armed conflict contexts. The ICRC has concluded that arguments based on the necessity to counter the spread of COVID-19 are not valid ground under IHL to deny consent to humanitarian activities, which is undertaken by impartial humanitarian organizations. Finally, it is worth underscoring that novel coronavirus does not observe battle lines and does not distinguish between combatants and civilians. Given the virus potency, states have a responsibility to deliver or allow aid organizations to deliver protective gear and treatment. Failing to allow humanitarian access necessarily increase the exposure of civilians to a virus that has already taken the lives of too many. The next international law that I will discuss is the human rights law. The measure adopted by many of the states to curb the spread of the virus have and will continue to have a restrictive impact on people's fundamental human rights. Nearly all states have faced significant challenges as they seek to protect their population from COVID-19 and prevent its transmission within and beyond their borders. Some states, however, have displayed particularly abysmal response, leading to widespread infection and deaths. For example, in Brazil, the president Jair deliberate effort to publicly deny the magnitude of the COVID-19 threat to the domestic population undermined public understanding of the disease severity. Such denialism contributed to a population-adjusted COVID-19 mortality rate that is one of the highest in the world. Many human rights are violated due to the action of some. And today, under human rights law, I'll be talking about 3 rights: right to life, right to health, and freedom of movement. First, the right to life. The right to life is a fundamental principle of international humanitarian law. Article 6 clause 1 of the International Covenant on Civil and Political Rights provides that every human being has the inherent right to life, which is to be protected by law, and no one shall be arbitrarily deprived of his life. The United Nations Human Rights Committee states the duty to protect the life of all detained individuals with the necessary medical care and appropriately regular monitoring to the health. In the committee meeting of the Tocient versus Canada, the committee found that the duty to respect the right to life extends to reasonably foreseeable threats and life-threatening situations that can result in loss of life. The failure of a state to take at least minimal steps to protect its population from the spread of COVID-19 arguably violates the right to life of those who become infected and die. States should ensure first responders and healthcare workers have access to necessary personal protective equipment, especially masks, to protect themselves and those they serve. Moreover, the law suggests that the right to life may be violated in some cases by denying access to health care essential to treating those at risk of losing their lives to the pandemic. The next one is the right to health. Numerous international declarations and conventions already articulated a human right to health. The non-binding 1948 Universal Declaration of Human Rights specifies in Article 25 that everyone has the right to standard of living adequate for the health. The World Health Organization declared that the enjoyment of the highest attainable standard of health is one of the fundamental rights of every human being without distinction of race, religion, political belief, economic or social condition. Epidemiological prevention and treatment, as well as healthcare access, are also facets of the right to health. Other relevant aspects of the right to health, which include access to safe and potable water and adequate sanitation, adequate food, nutrition, and housing. These basic facilities are lacking in many countries, contributing in harsh number of COVID-19. And until the base of the problem is not solved, right to health cannot be guaranteed. The next one, which is violated the most in this COVID-19, is freedom of movement. Freedom of movement is one of the rights most directly impacted by the measure taken by almost all countries in reaction to the COVID-19 outbreak. Countries have implemented worldwide travel restrictions as well as travel limitations within their own boundaries. The implementation of mandatory quarantine on travelers arriving from overseas, as well as the enforcement of isolation on the suspected or known to be positive for the novel coronavirus, has an impact on the enjoyment of one's right to personal freedom. State can take measures to manage the COVID-19 pandemic that interfere with some human rights by using limitation and derogation, but need to avoid any overly broad restrictions on movement and personal liberty. Yes. States should only move towards mandatory restrictions when scientifically warranted and necessary, and when mechanism for support of those affected can be ensured. As the pandemic is viewed as a public emergency threatening the life of a nation, the state can limit and derogate some of the human rights, but cannot derogate to non-derogable rights. But to avoid human rights violation becoming the new normal, states should focus on developing a long-term pandemic management strategy that does not rely on the continuing restriction or suspension of fundamental freedom. At the end, I would like to say that state parties to the international laws likely also have obligation to avoid impinging upon foreign populations' right to health. Consequently, state parties are likely to obligate to take reasonable steps to prevent infectious disease from spreading beyond the state's territory, to not disseminate pernicious misinformation about the virus that can mislead and endanger foreign populations, and to refrain from deliberately weakening other governments' capacity to provide essential care to their population, including through economic sanction. State parties likely have an affirmative duty to work cooperatively with other nations to contain the COVID-19 threat and reinforce health system. Finally, no one is safe until everyone is safe. These words, expressed both by the UN Secretary General and the Director of World Health Organization, underline the importance of international cooperation to overcome the COVID-19 pandemic. Thank you, everyone, for listening to me.
Thank you, Fatima Al-Muishi. Thank you for your presentation. The panelists will give you feedback later. Now I'd like to invite our second paper presenter, Mohammad Pavel Sarkar, Department of Law and Justice, Southeast University, to present his paper on unprecedented challenges and possibilities in ensuring quality of higher education, the redundant impact of COVID-19 on the backbone of Bangladesh. Mohammad Pavel Sarkar.
Thank you, respected moderator of the session, for allowing me to present. Let me share my screen first. Am I visible, sir?
Not yet. Yes.
Thank you, sir. I feel immense pleasure in welcoming the moderator, esteemed panelists, and keen audience of the session to my presentation. Today, I'd like to start the discussion on unprecedented challenges and possibilities in ensuring quality of higher education and the redundant impact of COVID-19 on the backbone of Bangladesh. And I hope which may be taken forward by concerned individuals having authority. A distinguished audience, as we all can relate to the ongoing destructive consequences of COVID-19, that the first case of COVID-19 was introduced in Wuhan back in 2019, and due to which students around the globe experienced gross level of educational disruption at an unprecedented level. So this discussion will enlighten how the backbone of a nation like Bangladesh is suffering from the lethal strike of a global pandemic. And the discussion will follow in these 4 steps. Similarly, the situation in Bangladesh has no exception to that. And as part of the preventive measures, the government of Bangladesh decided to close all educational institutions on 17 March 2020, continuing till today. And this affects 4 million tertiary level students around the country studying in more than 5,000 tertiary level educational institutions, providing education to them, which includes professional institutions, affiliated colleges, also public and private universities. And to address the situation, let us see them in segments like the sudden suspension of on-campus classes obstruct the learning process of students, as students do not have to follow any schedule to go to the university. So they are losing motivation to study day by day. The flexible nature of the online classes made the students inattentive to the lectures. Now they have scope of spending a lot of time in doing unproductive and non-academic activities like watching movies, TV shows, YouTube videos, spending more hours on social media like Facebook, Instagram, and unfortunately, very few students are utilizing the time with doing some productive works. Besides, as the announcement or to close all the institution was a sudden call, the student had to leave behind their books, their necessary academic materials in their halls or messes. And this is an interruption to their regular educational habit, which obstruct their access to necessary resources. Also, there are some expensive books and materials for which students are used to study from their institutions' libraries. And some homes, being a noisy and busy place to study for the students, they find it suitable to study in seminar halls or libraries, which in this pandemic situation is not possible at all. Besides, the distraction of social interactivity is a very important issue nowadays for the purpose of solving academic issues. The student back in before the pandemic used to discuss it with their friends and their faculties and in discussion with their group peers. But it was commonly practiced to discuss the debate over different issues and find solutions with friends. But consequently to this lockdown, the peer learning process has been hampered significantly, and as also the motivation to study may greatly hampered as there is no direct interaction with friends and faculties. Further, as a result, students are becoming introvert and to do even like they didn't like to talk with people like before. Consequent to these scenarios, students may end up forgetting to interact openly even with their known ones after the pandemic ends. So this may cause a lot of communication gaps in the post-pandemic period. More importantly, the effects on physical and mental health of the students cannot be denied. Some students are getting headache by concentrating in a single screen continuously for long hours, and some of them use headphones, which made the scenario more worse. Besides, students are growing fat by eating an improper diet due to the stay at home all day long, and with this bulkiness, most of the students feels tired and discouraged to stay active in online classes. Talking about the mental health of students, besides the fear of affected by COVID-19, there is a lot of other mental stress among the students. Stress gaining over the students is in a number of ways. Most of the students may feel less motivated, scared, and unfamiliar with the ongoing strategies which may drove them to a state of uncertainty and confusion regarding their next steps towards life. Further, students who stuck in their last semesters or exams, they're not yet graduated, but due to the long closure, the academic calendars are stretching. So the potential graduates are awaiting to pass and move to the job market, and this pandemic is obstructing their ways. And there are some graduates who have to take the responsibilities of their families on their shoulders, are now waiting for an uncertain period to remove this obstruction as well. Besides, for female students, there are some difficult situations ongoing around this COVID-19. The common scenario in our country is that families give pressure to female students to get married without fulfilling their education, as the education timing and their academic years are stretching. So this leaves them in a very hard mental state where they become unable to concentrate on study and not even study in other productive works as well. And for all these reasons, the government introduced online classes, and the shifting into online classes could not be appreciated unanimously because the poor infrastructure and educational arrangement in our country is not feasible to switch to online education all of a sudden. So the shortage of resources, skills, and practices by the educational institution is imminent and evidently loud to reflect the limitations of such decisions. A significant number of students to attend the online class regularly had no digital tool like appropriate mobile phone, computers, laptops, or tablets. Some even don't have a continuous internet connection in their homes, and they have to purchase expensive data bundles to attend the online classes, which are not at all feasible for them in this pandemic situation. Besides, in rural areas, students faced very poor network connection or no network at all. Frequent electricity obstruction is also an added issue in town and rural areas. There are a lot of students for whom using online device to join online classes all of a sudden is very difficult, as there was no institutional arrangement to make them operate such devices. And to attend classes, they have to make themselves prepared from a particular time. And as a result, most of the students are falling behind in the attending online classes where the system is running like an unrestrained horse. The family members of some students are also not at all familiar with this tradition of doing classes from home. So they are not at all cooperative. This makes the scenario more difficult for the students, and they did not realize the responsibility towards the online class of members of their families. And finally, the economic catastrophe of students are undeniable in this COVID-19, as this brought some significant financial hardship for some students and their families as well. As some students were bearing their own tuition fees by their own initiatives like tuitions, part-time jobs, and due to this pandemic, they lost their jobs, or which brought difficulties in continuing their studies, as all the tuitions or part-time jobs are stopped due to this pandemic. So even the families are facing hardship in bearing day-to-day expenses. As a result, managing the cost of education is an added high cost of internet packages is more impossible for them. So there are a lot of students from private universities facing economic hardship to pay for the tuition fees for their new semesters running online. Consequently, there is a study gap as they are unable to pay for their new semesters, and regrettably, they have to drop that semester as well. And day by day, these concerns are growing among the students. The financial hardships are also breaking the students' confidence and breaking their hearts, as their other classmates are moving forward with new semesters, but they are standing on the cruel reality created by this global pandemic. So these are some of the issues that, among others, are making the situation more worse, and these should be given more concern. We shouldn't take things like higher education lightly, where we are seeking solutions to this pandemic from researchers and scientists. Moving to the next phase, the global scenario is not an exception to that, and the transition from offline to online classes seems a bit easy for the nations that invested in the digital education sector and adhered to the digitalization process in a more strategic way. For example, Denmark, Estonia, Finland, France, and Germany. Unfortunately, countries that had no strategic developments towards the digitalization of higher education and did not provide the necessary attention to it are facing more difficulties in keeping pace with the challenges of upcoming times. This shaky state of international policymakers brought nothing but sufferings from students, and countries with technological advancement like USA, UK, China are also facing gross irregularities in deciding and shaping the education module more suitable for the situation. Unfortunately, no country has a suitable and appropriate legal arrangement to address situations like this. So now let's see the scope of legal arrangement and what are the issues ongoing in our country as well. Like the Constitution of Bangladesh under Article 17 ensured mass and universal system of education, and the government is to ensure such kind of initiatives for all through law. But this too is about elementary level of education, leaving the higher education out of the discussion. So we have to relate higher education in remote rights, like right to life is equal to dignity of life, and with the right to education, proper right to education is the proper dignity. So like this, but there is no single instances in our constitution directly adhere to the right to higher education. In this pandemic, the government is taking a lot of initiatives to meet the situation, but all arrangements seem scattered and unplanned. Looking into other aspects, here we can see that the University Grants Commission was established in 1973 through the University Grants Commission of Bangladesh order, and it is the supervisory authority of universities in Bangladesh. Later there are national university which are the supervising authority of all colleges that provide higher education in Bangladesh. All the medical colleges are respectively affiliated with the public university. Besides, in Bangladesh, public universities are autonomous bodies. They are regulated by some of their statutory bodies in accordance with the provision from their respective acts, like syndicates, senate, academic councils are the regulatory bodies of these universities. Further, in 1992, the Private University Act was promulgated by the government, and to that effect, it was repealed in 2010 by the Private University Act 2010. And the prime objective was that this private university will assist the government in its endeavors in meeting the challenges of ensuring quality higher education for all remains a mere statement till today. But this act only talks about the formation and procedure rather than quality of education, and regrettably, there are no such legal arrangements that can be followed to address an emergency situation like this COVID-19 pandemic. Further, the Private University Act of 2010 doesn't have any proper indication as to what should be the minimum preparation for the institution in situations like this, as there should be some specific guidelines or some emergency uniform set rules adopted to meet situations like this. Unfortunately, even in our country, there is no proper education law for the country, and a long-awaited educated proposed law of 2013 is still struggling for its way out with a lot of holdbacks. And as it seems like it doesn't address the need of higher education at all. It's specifically talking about the activities of the national universities after this pandemic attack. In March 2020, the exam schedule changed several times. Students even sat for several exams, but suddenly all other exams got postponed on a sudden directive from the Ministry of Education. And the scenario in public university is more worse, when everything else is returning to its normal state or adopting new strategies. The public university students are under grievance with the uncertain closure of their campuses across the country. The students of public universities are being deprived of academic activities, while the private universities and other tertiary level institutions are taking online classes. Besides these promises by the government, the vaccination promises of 1.3 lakh essential students and 15,000 teachers and other staff members of public universities before 17 May, it still remains a mere statement at all. And talking more practically, this ease of use of online education platform is a very important system continuing learning during this pandemic. But as the online learning system lacks the sensation of the conventional on-campus classroom environment, teachers and students feel demotivated and they lack the belongingness it needed to attend the online classes. So here there are some recommendations from this study illustrated, and based upon this study, after the pandemic, and thus the developing education-friendly legislation introducing all the stakeholders in the higher education system is important, with their liabilities under it to accordingly made them liable to cope with those kinds of acknowledge, sir. Accordingly, very important for the purpose of ensuring the implementation of effective online education in need like this corona pandemic, and to ensure quality higher education, the University Grants Commission must introduce regulations that all universities will be bound to use. And along with this, the highest authority can expand updated digital software and guidelines of using them with sole educational purposes. The government should take appropriate steps so that the students can access to the class easily, introducing these all issues. Further introduction of public policies to restructure the stipend programs for backward and poor students, and educational loans for the needy students to accommodate this global pandemic's needs and situations, and provide the stakeholders enough resources and support in continuing research related works and these all must be given priority. And further building compulsory infrastructure to facilitate online activities should be in the focus of the legal arrangement meant to address situations like this COVID-19. Also, joint initiatives should be taken for decreasing internet price, availing strong networks, making active interactions with families in distress, and further teachers and students should be trained and made skilled enough to administer online classes and exams. The guidelines for the evaluation system should be revised and made uniform rules, keeping in mind the present situation to justify the hard work of students and ensure the quality accordingly. And the necessary modules and equipment required for lab or other practical studies should mold in a way that they can be accessed online and by anyone, irrespective of financial or geographical position for the time being, and to address this situation. And clearly, as the online education system is not yet feasible option for Bangladesh at all, guidelines should be introduced to ensure the return to the institution for every student in this pandemic with safe and adequate safety measures. However, without having proper updated and responsive legal arrangement for our education system, we cannot expect to have maintained the regularities with the ensuring proper quality and effectiveness in our education system, as we are not familiar with situations like this, and we have to be ready if anything more devastating is awaiting in near future for us. Finally, to combat the challenges of COVID-19, strong and parallel collaboration between the government and the university authorities is inevitable. The government of Bangladesh needs to be at the lead of salvation from this crisis. And finally, to conclude, I'd like to highlight the reality that ensuring only the availability of higher education without quality in it is not sufficient for a country like Bangladesh to raise its head in support with its backbone. That's all from my part, and I'd like to thank everyone for being such a wonderful audience.
Thank you very much, Mohammad Pavel Sarkar. Now I'd like
Akram,
to... Yes, miss?
yes, I'm interrupting a bit for
Yeah, sure.
a little, because I'm not saying the presenter. Generally, in my all previous sessions, most of the sessions I have attended, and I found them, the presenter generally should be live. But so I would request you for the presenters, rather than they are not seeing themselves in the screen, they should be ultimately in the camera. Okay, thank you.
Thank you, madam. Now I would like to invite Ali Mashraf and Jalaluddin Ahmed, Department of Law, University of Dhaka, to present their paper on operation of virtual courts, impact of COVID-19 pandemic on access to justice in Bangladesh. Ali Mashraf and Jalaluddin Ahmed.
Thank you so much, sir. Am I audible?
Yes, you are audible.
Thank you so much, sir. Distinguished guests, honorable members of the panel, the organizers and co-presenters. Good afternoon and Assalamu alaikum. I am Ali Mashraf, along with my co-author, Mr. Jalaluddin Ahmed, LLM candidates from Department of Law, University of Dhaka, presenting today's paper titled Operation of Virtual Courts, Impact of COVID-19 Pandemic on Access to Justice in Bangladesh. We would like to begin with caution that this paper deals with virtual courts and not electronic judiciary. Now, how do we differentiate these two terminologies? Virtual courts mean the operation of court proceedings via virtual platforms where only the court hearing will take place online. Whereas e-judiciary means the entire process starting from the filing of the case documents to the court proceedings to the delivery of judgment will take place online, and the entire judicial system would become interconnected digitally. Now, we would like to begin by saying that virtual court system is a subset of the bigger set of e-judiciary. And our paper today will only deal with the initiation of virtual courts in Bangladesh and how it relates to the concept of access to justice. Then we will shed light on the existing legal framework of virtual courts, that the law that was enacted in 2020, the practice directions that were issued under the law by various circulars, and when the validity of the law was challenged, what the High Court division said. Later, we will show you, while operating virtual courts in Bangladesh, the picture of success and the challenges that our courts faced. Altogether, at the very end, we will share some informed recommendations for the stakeholders to make this system better and let this be a launchpad towards electronic judiciary. Now, access to justice, if we get into the concept, it's a fundamental right that is a broader issue of rule of law and good governance. Access to justice means where persons, and by persons we mean natural and legal persons, are entitled to receive their due rights as from this system. And in contemporary jurisprudence, the idea has transformed into effective access to justice. We mean accessibility, affordability, timely and effective access to redress mechanisms must be ensured for all citizens of Bangladesh under the realm of access to justice. Now, is access to justice specifically mentioned in our constitution, that is the supreme law of the land? We say no. However, the very essence of access to justice has been mentioned in various provisions in Part 3 of the Constitution, which contains the fundamental rights that should be guaranteed for all citizens of Bangladesh, irrespective of any of the differences. And even here, we can classify citizens into two categories. How so? One is, in general, the citizens of Bangladesh who will enjoy rights under the Constitution, specifically Part 3. The other are also citizens of Bangladesh. However, they're accused in criminal activities and they have another special class of rights in the same chapter of the Constitution. Article 35.3, therefore, in our opinion, is the main crux to access to justice for these individuals who are accused in criminal cases, as they have the right to a speedy and public trial in front of an independent tribunal. Whereas on the other hand, Article 27, equality before law and equal protection of law, as well as Article 31, which states right to protection of law and says that no action detrimental to life, liberty, body, reputation, or property of any citizens or person shall be taken except in accordance with law. This is generally applied to all class of citizens of Bangladesh. On the other hand, we have a special provision, Article 44, which states that when someone's fundamental right is violated, approaching the apex court itself is a fundamental right. Therefore, we see that the very notion of access to justice, although not verbatim, its essence has been in our constitution in Part 3. We would also like to mention one particular article, Article 33.2, which states that any person arrested and in custody should be produced before a magistrate within 24 hours, barring the time it takes them to reach the place of the magistrate. Now, why do we have we shed light on access to justice? Because this becomes essential when the court system is functioning. And our legal system mandates that the apex court of Bangladesh, the High Court division, as well as the appellate division, as the gatekeepers of the constitution, should be running throughout the year. Even when it's in vacation, there will be vacation benches. Whereas our criminal justice system will run 24/7, and there is no specific vacation for the criminal justice system. To shed light on access to justice, it is also an international law obligation of Bangladesh under various international human rights law instruments, For example, Universal Declaration of Human Rights in Articles 7, 8, 9, and 10 specifically mention our mandate of access to justice and in sort of way mirrors our constitutional provisions. The International Covenant on Civil and Political Rights also does this purpose about the right to free and fair public trial in front of an independent tribunal, as well as a right to a trial without undue delay, which further prejudices a person who is an accused in criminal case. Now, is access to justice only a part of civil and political rights or the fundamental rights? We say no. ICSCR does not contain any particular provision on access to justice, which is true. However, our economic and social and cultural rights are intricately related to access to justice. This is further propounded by the Sustainable Development Goals by the United Nations declared in 2015. SDG 16.3 mandates nations to the rule of law and access to justice. And we have seen in various research undertaken which show that access to justice not only creates better mechanism for ensuring CP, that is civil and political rights, but also ensures economic growth and equity and social justice, which further ensure the economic, social, and cultural rights, ESCR, of the citizens. Now we move towards the initiation of virtual courts in Bangladesh. How did it begin? Did it begin from a natural process? We say no. In 2020, on 8 March, 3 cases of COVID-19 were first detected in Bangladesh. 3 days later, World Health Organization declared COVID-19 as a global pandemic. The government of Bangladesh thereafter decided to declare a countrywide lockdown in the guise of general holidays for 2 weeks from 26 March 2020. The Supreme Court was in vacation at that time. However, vacation benches were running. The district court, that is the subordinate judiciary, was running at full pace. However, due to the worsening situation, the Supreme Court Circular number 194 declared the vacation for both the divisions of the Supreme Court, as well as all other subordinate courts of Bangladesh from 29 March to 2 April 2020. This vacation by the government, as well as closure of courts, was extended from time to time later by gazette notifications and circulars by the government and the Supreme Court, respectively. From 29 March to 11 May 2020, for more than a month, all courts of Bangladesh went into holiday and there were no trial procedures taking place. Even trial procedures did not take place in magistrate courts, although magistrate courts were open in limited capacity in order to ensure its constitutional obligation. Meanwhile, what about the interlocutory orders and bail orders that were issued by the courts? Our Supreme Court, by various circulars and memoranda from time to time, increased the time limit or the operation of those orders and interlocutory orders and bail orders. Now, was justice even available at that time? We say no. Let alone accessible, justice was not available because the courts were not running at any capacity. The apex court, which guards the constitution, remained in vacation for more than a month. And we also know that the subordinate judiciary, the civil court system, was totally in vacation. The criminal judicial system, although in limited operation, did not hold trial procedure during this time. Thereafter, the Chief Justice requested the President of Bangladesh to promulgate an ordinance, and afterwards, under his power of Article 93.1, the President of Bangladesh promulgated the use of information technology by Court Ordinance 2020, paving the way towards initiating virtual court hearings in Bangladesh. The ordinance later became an act which contains 6 sections. We would like to shed light on some of the important provisions of the act. The preamble states that the act was promulgated to ensure virtual presence of parties in 7 occasions: holding trial or inquiry, hearing application or appeal, taking evidence, hearing arguments, issuing order or judgment by the courts. Point to be noted, this did not mention about filing of new cases. We also see that virtual presence was defined in Section 2E as any person's presence in the trial procedure via audio, video, or any other similar electronic media. There is also a loophole in this definition, which we will shed light upon later. And Section 3.1 empowered courts to conduct proceedings by using information technology. The crux of this act was in Section 4, which says that if the virtual presence was confirmed as per Section 3, the obligation for someone to appear in person before the court in our procedural laws, mainly the Code of Civil Procedure and the Code of Criminal Procedure, as well as any other law enforced, would be deemed to have been fulfilled. Now, this act also kept place for numerous additions in future. In Section 5 empowered the appellate division and in cases the High Court division to issue practice directions from time to time, which is in consonance with Article 107.3 of the Constitution. Now, if we give you a holistic picture of the practice directions to the appellate division, the High Court division, and the subordinate judiciary, we see that for the Supreme Court, that is the AD and the HCD, lawyers had to attest a one-page application stating the urgency of their matters that they were bringing before the court. And the chamber judge of the appellate division was empowered to hear and dispose of urgent appeals, whereas the High Court division benches, 3 at that time, were only dealing with very urgent writ and civil matters, criminal and bail matters, and miscellaneous matters. On the other hand, our subordinate judiciary, civil courts were totally off, and only bail matters were being heard by the magistrate courts. There was a confusion regarding the platforms to be utilized for virtual court hearings. The practice directions of the Supreme Court said that the parties would be using either Microsoft Teams or any other video conferencing application, whereas the subordinate court circular said video conferencing platforms would be Zoom, Google Meet, or Microsoft Teams. We see a sort of inconsistency between the practice directions there. Moreover, other practice directions were issued from time to time by our Supreme Court, circulars extending the operation or limitation period of various interlocutory orders or bails, increasing the number of benches in the High Court division and the subordinate courts, ordering virtual hearing in civil courts for very urgent civil matters applications, as well as very recently, all subordinate courts and tribunals were ordered to hear and dispose of all types of civil and criminal revisions, appeals, and hear arguments, and even deliver verdicts in civil suits virtually. Now, after the virtual courts were initiated, in August 2020, in limited capacity, courts started functioning virtually. The Act of 2020 was challenged in the High Court division in the writ petition 4611 of 2020. The petitioner challenged the legality of the law due to being inconsistent with Article 35, 81, and 82 of the Constitution. The High Court division summarily rejected the writ petition, upheld the legality of the law, and even elaborated on 4 crucial issues which would ensure better application and enforcement of the law, which are access to internet, digital literacy, due process, cybersecurity, and privacy. Now, let me give you a snapshot of the success of virtual courts. In the first 10 days from 11 May 2020, 33,287 bail petitions were heard, and bails were granted to 20,938 individuals. In the first 35 days till 22 June, bail petitions were heard 95,523, and 49,762 prisoners were granted bail. Before the courts opened physically until 5 May, from 11 till 5 August, total number of bail petitions that were heard and disposed of stood at 136,399. And over the span of the last 2 years, the last 2 lockdowns, and in the 1 year of virtual court, from May 2020 to 24 May 2021, 215,000 bail petitions were heard, more than 106,000 detainees were released from prison. The appellate division disposed of more than 10,000 cases, and High Court divisions were disposing of more than 500 cases per day. But is it all about the success? We say no, there were numerous challenges that our courts faced. First of all, the operation of fundamental rights, which further relates to access to justice of citizens, was de facto suspended. We've already told you during the beginning of the pandemic how courts were in total closure for more than 1 month. Even when the courts started operating in limited capacity, it was not able to cater to everyone's right to justice. We know that only bail matters were heard at the very beginning. A study by BRAC, Human Rights and Legal Services, says from 21 March to 9 April 2020, total number of violence against women and children reported cases was 262. None of these 262 cases at least could not see the light of the day in the courts due to courts only hearing bail matters. We've also seen how people were arrested under the Digital Security Act 2018 and other laws and were not produced before courts, and thus it violated their rights, fundamental rights, under Article 33 and 35 of the Constitution. Secondly, we also see some of the loopholes in the Act, the preamble not mentioning anything about filing of new cases. This gave rise to some conflicting interpretations, which was thankfully later resolved by the Appellate Division's order in Civil Appeal No. 28 of 2019. We've also showed you how virtual presence was inaccurately defined. It did not differentiate between real-time virtual presence and pre-recorded virtual presence via video conferencing. Real-time presence must have been inserted in the definition of virtual presence. Moreover, the 2020 Act was insufficient to conduct all stages of a suit or trial virtually because the procedure was more of physical court in nature. We have to mention, as you can see on the screen, that the Bangladesh Law Commission had a draft সাক্ষ্য ও বিচার কার্যক্রমে তথ্য প্রযুক্তির ব্যবহার আইন, the English of which is Use of Information Technology in Evidentiary and Judicial Proceedings Act 2019. But the government, the legislator, did not enact this law. As a result, only limited functioning of courts could be ensured. We have also showed you some of the challenges regarding the inconsistencies in the directions. We'd also like to tell you about the security concerns due to use of third-party open source platforms, Zoom, Google Meet, etc. Gmail addresses were being used to share confidential case data, which could have been compromised at any time by hackers. And lastly, lack of uninterrupted power and internet connection and lack of digital literacy is always a problem in Bangladesh.
Please complete your presentation within 5 minutes.
Thank you so much, sir. But the biggest problem of all is the increasing backlog of cases. The current figure of backlog of cases is 38 lakhs. And with the limited function of courts, it is feared that it may rise to even 50 lakhs. Based on these problems, we would like to offer some recommendations to the stakeholders. Firstly, we say that the 2020 Act should be amended in light of the recommendations provided by the Law Commission. The Law Commission in a report asked the government, the parliament, to amend some of the provisions of the law. The report which we have shown you on the screen is available on Law Commission's website. Moreover, we have already told you how the 2019 Draft Use of Information Technology in Evidentiary and Judicial Proceedings Act must be enacted in order to complement the provision of this law. We've also would like to recommend that cases and suits which are in the judgment stage can be disposed of virtually. The Supreme Court circular, which was recently issued, also asks courts to do so. And a new protocol for operation of virtual courts can be initiated. Some of these are already in the draft law, and some others might be framed under rules under the Act. India has already done something in regards to this, as we are showing you on our screen. Their draft rules on live streaming and recording of court proceedings. Now, we have already shown you the draft 2019 Act. However, we are also showing some of the important provisions which you can see from the screen. And once these are implemented, it becomes quite easier for our courts to take the trial process virtually or on video conferencing platforms. We also would like to suggest bigger and more secure servers to install in Supreme Court and in other subordinate courts. Justice M. Imran Ali in a recent webinar stated that more courts were not functioning due to lack of space on the server. We believe premium services can be availed in this regard, and budgetary allocations must also be made. Currently, the budgetary allocation for the judiciary stands at 0.345%, and it never rose to more than 0.5% in the last 5 years. Ideally, budget for the judiciary should be 1% of the entire budget of the nation. We believe a change must be ensured in this area. We would also like to state that budgetary allocations on internet accessibility, fiber optic connection, strong mobile connection, and internet bandwidth and data must be looked into, and the government must pay heed to these areas. Moreover, we must also give more emphasis to alternative dispute resolution mechanisms to reduce backlog of cases. ODR is now a popular mechanism all over the world. In Bangladesh, this must be initiated, and ADR, which is mandatory under sections 89A to 89E under CPC, as well as other laws currently in force, and some of which the High Court has even directed the courts to do so, the Money Loans Court Act 2003 and the Labor Act 2006. In all these cases, suits, trials, ADR must be initiated at the quickest time possible in order to reduce more cases going to the trial phase as well as the appellate phase in our apex courts. We'd also like to state that training has been an issue, and we believe a coordinated approach by the Bar Council, Supreme Court, District Court, Bar Associations should be provided, and video conferencing facilities must be given to the lawyers. We have given you some examples of some of the success of other common law countries today regarding virtual courts. The example of UK and the example of Australia can be modified according to the needs of Bangladesh, and thus we can ensure best practices of other countries, suit them to our needs, and at the end of the day, make virtual court system more effective and successful. In the end, we would like to say that training, increase in budgetary allocations, and coordination between all stakeholders is needed to increase the effectiveness of virtual courts and ensure access to justice for all. And we believe more emphasis should be given to our subordinate judiciary. Thank you everyone for your patient hearing, and we would like to invite informed comments, recommendations from the panel of experts as well as all the presenters of this session. Assalamu alaikum.
Thank you, Ali Ashraf, for your wonderful presentation. Now I'd like to invite Bharat Kumar Rohalan, Department of Law, Amity Law University, Jaipur, India, to present his paper, the last paper of this session on rule of law and pandemic in India. Bharat Kumar Rohalan. I think he's absent. Okay, we have listened all the paper presentations. The titles of all the papers are very timely. Here is the end of our paper presentation. I'd like to congratulate all the paper presenters for their wonderful presentations. This is the time to hear valuable feedbacks from our distinguished panelists. First of all, I am requesting our distinguished panelist, Dr. Jamila A. Chaudhary, Professor, Department of Law, University of Dhaka, to give her feedbacks.
Okay.
Madam, please.
Yep. Thank you, Akram, for giving me the floor to say something on this precious occasion as one of the panelists in this session. I'm a bit disappointed that amongst the four speaker or presenters, it is Bharat Kumar. Is it so? He didn't. Yes. Yeah, he didn't present his paper, though according to my guideline, he should be the first in my line. However, I must appreciate UNESCO Madanjit Singh South Asian Institute of Advanced Legal Studies, Human Rights Studies, that means UMSAILS, in partnership with Department of Law and Human Rights, University of Asia Pacific, for organizing such event, that means virtual international conference during this COVID pandemic. It would not be an exaggeration if I just mention that University of Asia Pacific is the pioneer of these kinds of virtual international conference during this pandemic in Bangladesh. Though previous this even including University of Dhaka has organized several international conferences, however, that was not the virtual one. So for my knowledge, it is University of Asia Pacific, which is the pioneer to pave way this path of organizing virtual international conference. Thanks the organizers, both UNESCO Madanjit, South Asian Institute, as well as Asia Pacific. After the launching of this UMSAILS program since 2020 from the University of Asia Pacific, I have ultimately got the opportunity to take in the class and attach myself with both UMSAILS program as well as regular program. So I have also got the opportunity to see them both physically in the first phase, the first year of the UMSAILS program, at the same time virtually in the second phase, which is running on now due to COVID. So here I got the difference. So the difference is huge. you may ask the question why suddenly this point ultimately arose. My point is that the difference between physical teaching pedagogy or learning pedagogy and online pedagogy, COVID doesn't make ourselves confined only within, or it didn't influence our life only within this academic arena. Its impact is huge. And ultimately, we are seeing that in all aspects, especially nowadays, we are seeing when we just compare with other arenas, we find that it is one of the high platform, that is the academic arena, which is suffering most due to this COVID pandemic. So far what I have said, perhaps it give you a light or shed a light that I'm saying something, and almost most of us, we are seeing the negative sides of the COVID, including myself. However, against this dominant discourse of the negative side of the COVID, I have some observation of COVID-19 that has also some positive sides that I shared with my students, both private and public. It is because of that positiveness that we are here today. Do you think that if COVID is not there within us, I'm not supporting COVID, that it's a very good, it's a blessing things for us, but within a invisible enigma, within a enemy which is not visible, we should find some good. If it is really contains, we should pronounce that one. So in today's platform, if I link the positiveness of COVID-19, I must say both national stream and international stream, we combined together. We got the opportunity to combine these two different streams at the same time simultaneously due to the COVID's positive impact. So while dealing with the impact of COVID, so far I have heard all the presenters from yesterday is ultimately focusing, excepting a few, saying something which are mostly negative. So it is not the proper platform to say the positive COVID impact versus negative COVID impact. Thus, I will just keep this point, just pointing a very important point that COVID does have also positive sides. So now it's my time to turn ultimately my main focus. That means to share some observations, comments on the 3 papers that were presented in this session on the impact of COVID-19 pandemic in the legal field. Let's begin with the first presenter, though it is assumed that the first presenter would be Bharat Kumar, so he was skipped. So now it was presented by, the first presentation was by, it is Fariha Tasneem and Fatima Alom. Is it so? The
Yes.
first one, international law and COVID-19. Yes. So it is presented by Fariha Tasneem. But so far
Fatima Alamushi.
but it is from Southeast. I have Pavel Sharkar is from Southeast. Is it so?
Yes, ma'am.
The first presenter was.
Yes, ma'am.
Can I see you? The first presenter, please. Can you on live? Pavel Sharkar, the second presenter, is on live. I'm not seeing this presenter.
Ma'am, his camera is on.
Okay, thank you. Okay, so your title was International Law and COVID-19. To me, it's my subjective opinion. It could be different with others, and you may or may not take my observation or feedback. It's up to you. Obviously, you are the researcher. You are the framer of the article. It is you who has the entire ownership of your article, which feedback you will take, which will not. However, as one of the panelists, I will not go much details on your presentation, but very basic points I would like to focus. The first one is relating to your title, International Law and COVID-19. My first question is to you, if it is possible, after finishing my part, I appreciate if you just answer me these questions.
Ma'am, sorry to interrupt. International law and COVID-19 was presented by Fatima Alamoishi and Fariha Tasneem Mitu, not by Pavel Sharkar.
I'm not saying about Pavel Sharkar. I'm saying about the first speaker. That means
Yes,
international law and COVID-19. That is you.
Fatima Alamoishi. Yes, ma'am.
Yes, ma'am, but right now
Yes.
she is not present.
Whoever present, please.
Yes. Yes, ma'am.
Since it's a co-authored article, at
Yes,
least
ma'am.
one of you should be present there. Isn't
Yes,
it?
ma'am. Yes.
Obviously, you cannot expect that only after the presentation you will wipe out from the session. You must
Yes,
be
ma'am.
there up to the end, and you have to wait what the panelists. There are two panelists here. One is our very respected panelist who is after me. You should wait to hear what they are saying to you.
Yes, ma'am.
So, yeah, thank you. So my first question is, as I said, title is too broad. This title doesn't give any particular focus. Which part of international law? Is it private international law? Public international law? If it is public, your PowerPoint presentations, some of the slides have mentioned that UN COVID chain task force. This notion was there. In another slide, you have also mentioned Article 43 of the International Health Regulations. In another slide, you have also mentioned International Refugee Law, International Committee of Red Cross, International Human Rights Law, etc. So you are covering all the aspects of this international law in one article. Do you think it is feasible? My question is for you.
Yes, ma'am. We tried, but yeah, we know
Not
that.
now. I said you, after finishing all my sayings, all my observation to all the speakers, you will get chance to answer me.
Yes, ma'am.
For the time being, just note down the point, what I'm saying. Secondly, again, it's my subjective opinion. Since you are focusing most of the slides, you have given emphasis, if I am not wrong, and if I am not properly understood, you have given emphasis, since the theme of this international conference is COVID, that is relating to health issues. Also, most of the slides of what you have presented is dealt with health issues. So my view is that you can rephrase the title. For example, global, that means something relating to international health issues. For example, it could be global public health law. Global means international. So this kinds of thing, if the initiation of your article, the initiation is started with the title, which is very core, the heart, I think, in my opinion, of your article. It should be consistent, that title should be consistent with your abstract as well as with your long presentation, long paper. Okay. Nonetheless, I must appreciate that as a young researchers, obviously there must be, not maybe, if I were in your position, obviously at this situation, I also made several wrongs. So don't take that we are criticizing your article very rigorously, or don't take it negatively. Rather take it generously, that it could happen because it's my first or second or very elementary participation of an international conference. So obviously, I highly appreciate both the authors' courage, that despite knowing that some of the lacunas would be there, nonetheless, you are here. Thank you so much. The first two authors on international law and COVID-19. Okay, one thing, if I don't mention that one, perhaps it would be a massive point that I think should not be omitted by me. Regarding your methodology, you didn't mention anything about your methodology. Did you? If so, please give the answer at your answer session, please. And lastly, my question is regarding your one or two key findings. What have you ultimately found by dealing with this article, by your literature review or primary, if you do, since you didn't do any methodological component, you didn't insert, I don't know if it is based on secondary data or empirical study or primary data. So please mention, I will happy that if you clarify me what would be your one or at least one of the key findings of your article. Secondly, it was presented by Pavel Sharkar, titled Unprecedented Challenges and Possibilities in Ensuring Equality of Higher Education, the redundant impact of COVID-19 on the backbone of Bangladesh. In terms of, again, Since I really give emphasis on title initially at the very first glance, here also, the theme of the title is good. However, the number of the words, I don't know whether it is known to you or not. Title should not be too big. So the number of the words here as a title of the article, again, in my opinion, is too big. Number two, in the redundant impact, it is not very clear to me. What do you mean by redundant impact of COVID-19? And number three, the backbone of Bangladesh. When you say the education sector, in other words, it is the backbone of Bangladesh. It is the backbone of a nation. So some words you can omit to make the title more convincing with lesser words. It could be like that. For example, COVID-19 and quality higher education in Bangladesh, unprecedented challenges and possibilities. Again, it's up to you whether you will accept it or not. But remember, some words like redundant, if you cannot clarify this one in your long version, that means long paper or PowerPoint, when you present it, then it is obscure to me, obscure to the audience who are there. For me, still I didn't know what do you mean by redundant. So I will wait for you, and I hope you will give me a convincing answer. What do you mean by redundant? In one of your slides, you have mentioned distance learning, and another slide, and in other slides, mostly you have ultimately dealt with online learning. These are two different segments. They are not same. So better for you, again, to make a distinguishment between distant learning and online learning, which is going on now in Bangladesh, as well as to many of the countries of the world. Again, like the earlier paper, no explicit methodology. It is, again, remember, please, keep it in mind very carefully. Methodology is one of the cornerstones of your abstract. And your abstract is ultimately lead to you to your longer paper or presentation. Your ending, if I compare with the that means the first speaker's presentation, obviously your ending is good. There are some key findings you have highlighted. So thank you so much, Pavel, for your nice presentation. As a young researcher, it is obviously, I will say to everybody, it is obviously, we must appreciate these young researchers to proceed, move on further, so that and your next presentation would be better. Then sometimes we will expect it would be the best.
Thank you, ma'am.
Okay, thank you. Now, last but not least, because there is another session after that, it is presented by Ali Mashraf and it is a co-authored article, Ali Ashraf and Zalal Ahmed. The title of the article is Operation of Virtual Courts, Impact of COVID-19 Pandemic on Access to Justice in Bangladesh. So Akram, just at this point, can I just request you to go back the cover page of our brochure? Is it possible? If
Yes.
it is not give much pain to you.
No, please.
And Mashraf and Jalal also. Think something. I'm approaching towards that cover page of the brochure that was circulated to all of you relating to this virtual code. What kind of question I may ask? Yes, thank you so much, Akram, for taking this pain. Okay, Mashraf and Jalal. You have nicely depicted, really a nice presentation. So many informations, very recent insertion by the High Court Division, enactment of the laws, all are inserted. But why have I jumped suddenly to this cover page? Since you have identified e-code and virtual codes, they are different. Now my question to you again, this cover page relates to what? Is it e-code? Is it virtual code? And or something else? See very rigorously this picture. I would eagerly waiting to get a very convincing answer from you from this image. Next, again, title is my mission to go forward to hear next part of your article or thesis, the longer part, whether it is PowerPoint or it is hard paper presentation. You have said access to justice in your title. One of the notion you have inserted access to justice. However, again, access to justice, perhaps you know, it is of two folds. Formal access to justice, informal access to justice. So you didn't narrow down the scope that here you are not dealing with informal access to justice. You are only dealing with formal access to justice. So when you say access to justice, it's a very broad notion covering both formal access to justice as well as informal access to justice, including mediation, conciliation, arbitration, etc., and hybrid ADR. Obviously, again, since I have mentioned two of your earlier colleagues, to rephrase, it would be better if you just rephrase the title. Perhaps it could be better. So for you, it would not be an exception for me. It could be rephrased in many folds. However, for example, how is it, you just think? Operation of virtual courts, impact of COVID-19 pandemic on access to formal justice, access to, repeat, access to formal justice in Bangladesh. So everything is covered, that it is formal. At that time, you don't need to say something in the scope or limitation that this paper is only concentrating formal access to justice, deducting informal access to justice. Nonetheless, it's really a good presentation. If I just compare with other presenters in this session, in 2020, the enactment of 2020, which has been enacted in July, comprising of 6 sections. I have one very crucial question to you. You have inserted in your abstract that confusion arose. That means that enactment didn't cover all the ambiguities due to very brief comprising of 6 sections only. Consequently, confusion arose while dealing with this enactment, as well as dealing with this enactment by the courts. But again, to me, how this confusion arose, why this confusion arose, there is a missing linkage. The story, there is something lapsed while making a good story. Altogether, as I said earlier, obviously, needless to mention, it is one of the best papers so far I heard, not only today, also yesterday. So thank you so much. So Akram, is it possible for you to give the floor to Sir first, so that he can?
Yes.
And then
Okay.
then we can share the answer from the participants.
Okay, ma'am.
Okay, thank you.
Thank you, madam, for the feedbacks. I believe your feedback will greatly enrich the participants' papers. Now, I'd like to request our another distinguished panelist, Mr. Iqtedar Ahmed, former Registrar General, Supreme Court of Bangladesh, and Chairman, Minimum Wages Board, to share his feedbacks.
Thank you, Mr. Mohammad Saleh Akram, and thank you also, Professor Dr. Jamila, for your wonderful discussion. So long we have heard deliberations of the presenters and panelists. Although 4 presenters were supposed to present their papers, but in reality we found that 3 presenters, and among those 3, 2 were joint presenters. They presented their papers. What I find, all the papers are rich. The presenters put a lot of endeavors to prepare such analytical paper. I appreciate their efforts. I also appreciate the initiative of Asia Pacific University for organizing such time-oriented international seminar. Now, in a nutshell, I will try to give my remarks on the papers so far presented. The first paper, which was presented by Fatima Alam Oishi and Faria Taslim Mitu. The title of the paper is both of them are from the Department of Law and Human Rights, University of Asia Pacific, Bangladesh. And their title of paper is International Law and COVID-19. In their paper, they laid importance on the role of 4 international organizations, namely World Health Organization, then International Refugee Law, then International Humanitarian Law, and International Human Rights Law. Their paper aims assessing results based on different regulations of health-related international organizations. In their paper, they have tried to lay emphasis the threat of COVID-19, the risk which has been which has been now being faced by different countries of the world due to actually transmission across borders, and for its prevention there is need of concerted international response. Then the next paper was presented by Mr. Mohammad Pavel Sarkar. He is from Department of Law and Justice, Southeast University. His paper is unprecedented challenges and possibilities in ensuring quality of higher education, the redundant impact of COVID-19 on the backbone of Bangladesh. In his paper, he highlights how COVID-19 is affecting the quality of higher education and students in Bangladesh and probable way out to overcome the crisis. Then he discussed reasons behind closing educational institutions, mainly to stop spreading of the virus. In his paper, he has said online education is not proper solution. He has also highlighted that how families and students are affected. Then closure of residential hall is impediments towards lodging of students, resulting discontinuation of their tuition, affecting their earning from part-time job. They are in difficulty to maintain themselves and giving support to the family. Then they discuss that the government is taking different measures, but these are not enough to fulfill the aspiration of the student. Then they discussed about the quality of education now in our different higher educational institutions. It is known to all that the quality is deteriorating day by day, and it is mainly due to actually quality of teachers. If teachers are recruited on political consideration, then it will be very difficult on the part of the higher educational institutions to maintain the quality. And actually, in many national debates, this question was raised once again. In pre-liberation period, our prestigious Dhaka University, that was one of the prestigious universities of the world, and it is used to be called as the Oxford of the East, but its past glory has been lost. Now, actually, it is not within 1,000 best universities of the world. If we like to actually improve the quality of university, then the quality of the teachers must be actually ensured, and in every department, the student who are doing best result in the examination, they should be recruited, and under no circumstances any teacher should not be recruited, or any teacher should not be appointed on political consideration. In different public universities, we have found that as teachers are recruited on political consideration, the quality of education is deteriorating, and it is also polluting the actually academic atmosphere of the university. So I think our policymakers, they should actually look into this, and unless this problem is resolved, our quality of education will continue to deteriorate, and it will actually, in the long run, it will affect the whole country, and it will affect the nation. So this has now become a national issue. Then the next speaker, I think this paper was also jointly presented by Mr. Ali Mashroof and Mr. Jalaluddin Ahmed of Dhaka University. Title of their paper is Operation of Virtual Courts, Impact of COVID-19 Pandemic on Access to Justice in Bangladesh. This paper tried to find out impact of COVID-19, access to justice and loopholes in present virtual court system. In the paper, in a very nice manner, they have tried to find out the difference between virtual courts and e-judiciary, access to justice. In their paper, they have also mentioned that the number of cases now pending
I think Sir's internet connection has lost.
Yes, Graham, I thought it's my computer network issue.
No, listen.
I'm not hearing anything. So we should
Let
wait
us
for
see whether he will join or not.
Yes, obviously, we should wait for him, please.
So, let me call him. আমি কল করে একটু জানার চেষ্টা করি।
স্যারকে আমি পেয়েছিলাম দুইটা ক্লাসে, আমি যখন ক্রিমিনাল ল ক্লাস নিতাম।
Madam, yes, it is a live program, so shall we continue?
disconnect. আমি তো চেষ্টা করতেছি তো।
Oh, sir, yes.
হইছে
Yes, please, sir. Yes, you are audible, sir. Please continue. Yes.
Then actually, you have said about ADR. One of the ADR is actually arbitration, and arbitration, it is the scope of arbitration in civil cases is not also wide. It is also applicable in domestic and international contract if there is any arbitration clause. And unless there is arbitration clause, the arbitration jurisdiction cannot be invoked. Now, if we can actually enlarge the scope of arbitration, and if we can make it applicable to all types of civil cases and also criminal cases, then huge number of civil and criminal cases could be actually disposed of under the scope of arbitration. And I think this will enable to actually reduce the backlog of cases which the courts of the countries now are facing. Another thing is that there is a acting judge system. When I was Registrar General of the Supreme Court, I had the occasion to visit Australia to study their legal system along with the Chief Justice and two other judges of the Supreme Court of Bangladesh. And there we found a type of system which is called acting judge. In Australia, retired judges are called acting judge, and in the courts where there are excess number of cases, those cases are referred to the acting judges for disposal. And by introducing this system, it has been possible on the part of the Australian judiciary to reduce their backlog. So these are the actually scientific system. If our legislatures, our policymakers, our think tank, they think about actually ADR, they think about mediation, they think about arbitration, and they think about, I think, acting judge system. I think the problem of backlog, this can be addressed. And unless this problem is addressed, day by day, the number of cases will increase. And in one day, actually, it will become burden for the whole nation. And the concept, actually, access to justice and speedy justice, those will be actually take, or those will be gone away from the actually jurisdiction of our law books. So this problem should be actually addressed to actually give redress or relief to the actually people. So I appreciate the actually initiative, endeavor, and efforts of the researchers. And among the researchers, two are very young. They put a lot of efforts to prepare the paper, and their initiative must be actually encouraged. And if in future they continue or give effort in preparing this type of paper, and the organizers also in future, they actually take step or take measure to organize this type of seminar at least once in a year. This will help our researchers to improve themselves, and this will also enhance or increase our capability to organize such type of seminar. It is a good effort. I appreciate the role of the organizers, the initiative and the effort of the organizers. And I also actually like to give them thanks for inviting me to be one of the panelists here. Actually, my first panelist, Dr. Jamila, she actually discussed a lot about the each of the papers. So I do not like to enter more in detail about the papers, but I appreciate the role of the researchers, and I think in future all of them will come out as good teacher, as good researcher, as good academician, and this type of practice should continue for actually enhancing our capability. And our judiciary, I think, in future will be benefited if this type of seminar is organized by each and every university. I like to thanks all the organizers present here, the researchers present here, the students present here, especially Dr. Asad. He's very capable person. We work together in the Southeast University for long. I think Mr. Asad, you will continue to give your effort in organizing this type of seminar in future also, and you will also engage us and other academicians of the country so that the seminar will be meaningful and the country will be benefited. Thank you very much to you all.
Your words have enlightened us a lot, sir. Thank you very much. I hope the participants have taken note of the comments of our distinguished panelists. Now I am requesting the paper presenters, if you are interested to answer our panelist questions, or if you have any query, you can ask them one by one.
I
Thank you, sir, and thank you, ma'am, for your kind comment about our research paper. Basically, this was the first research paper, and we learned through our experience, and we also basically we gave the title about the international law and COVID-19 because we wanted to show the relationship between international law and COVID-19, but we also acknowledge that the title is too broad, so we will take consideration about it. And the methodology we used here is a secondary data, and our research is based on the analysis of selecting international legal acts, position of representative of doctrine and documents, comparing countries with different results. And the main key finding of our research paper was the relationship between international law and COVID-19. That's it. Thank you, ma'am.
Okay, thank you so much.
Thank you, Mitu. Then Pavel Sarkar.
Thank you, ma'am. And it is my privilege to hear from you and getting the detailed instruction regarding preparing research like this. So I am honored and privileged to hear from you. And I'd like to take your suggestions on giving a good title to a paper, because I believe that a title attracts at first impression. So thank you, ma'am, for your kind suggestion. And I use the word redundant to just reflect the unnecessity of the impacts. Like some may say the online classes are more flexible. Some may say the online classes are more useful to avoid traffic jams, to prepare for classes, to access books rather than PDF files. So, for those reasons, I use the word redundant as a synonymous effect of unnecessarily or unwanted impact. But I would like to correct my lacunas according to your suggestion. And the word distance learning, actually I was referring to digital learning process. Maybe I mispronounced during my presentation. So it is my I beg your apology if I mispronounced. But I was referring the digitalization process. As we can see, there are a lot of countries before the pandemic, they are going to digitalize their education system. So I was referring to the digitalization process, and I used and I mentioned the methodologies in my paper earlier, and it didn't come out in the presentation because I think as there were no compulsory directives regarding the presentation, so I used a compact and easy way to present my paper in a more informal way. So for that, I skipped the part. The research used was done by using secondary data, and it is an analytical approach by analyzing the present situation, and all the necessary and all the available instruments around that I can have access in this recent time. So these are all my observations regarding the queries, ma'am. And thank you, sir, for your kind observation on my paper. And I'd like to continue my further studies and further research works with such inspirations from you and ma'am. So please keep me in your prayers, and your encouragement, your paths shown by you team panelists will always inspire us. Thank you, University of Asia Pacific, for arranging such programs.
Thank you so much, Pavel.
Ali Masraf.
Thank you so much, Jamila ma'am and Iqtada sir, for your very precise presentations. So at the beginning, I would like to thank ma'am for pointing out the poster of the conference. However, even yesterday, a Supreme Court circular by the Chief Justice said all 53 benches of the Supreme Court is being now moved online. So there is still no initiative due to the scope and the spread of coronavirus to have even distancing or in-person attendance in the courts. And that is the reason why we have based our presentation on specifically virtual courts and distinguished it from e-judiciary, which is a bigger project in itself. But yes, the poster is also something that needs to be looked into, whether in future, if we can go into a more physical plus digital accommodation. That will definitely.
Mr. Ali Mashraf, I'd like to interrupt you for a moment.
Yes,
actually, I have an engagement in an embassy today at 6, so I like to leave now. So I actually seeking apology, and actually I'm to leave now. Mr. Salakram.
Sir, thank you, sir.
Thank you.
Okay, sir. Thank you, sir.
Thank you, sir.
Joining, sir. Yes.
Thank you, sir. Assalamu alaikum, sir.
Thank you, sir. Assalamu alaikum.
Thank you so much, sir, for your comments as well. Secondly, ma'am, the reason why we did not want to demarcate formal and informal access to justice is because in the introduction part of our paper, we have specifically mentioned why this will be based on formal justice and not informal justice system. And even then, at the end of the introduction, in the last sentence, we have also written that even then, some recommendations from the informal sector will be provided in the last section of the paper. And that is the reason why we did not want to limit it to the words of formal, but the scope that it's been reduced to formal justice system has already been mentioned in the introduction of our paper. I think we should have brought it into our presentation as well. That could have cleared the confusion earlier, but we'll definitely keep that in mind while presenting in order to make sure that all the information are put together while during oral delivery of the presentation. Thirdly, ma'am, regarding the confusions, we have already stated that the CPC, CRPC and other procedural laws had mandatory provisions where the physical delivery of evidences, hearing of arguments had to be taken in person in the court, whereas in circulars, there were different directions in the beginning. At the same time, the increase of time limit of various orders, it was not clear when the limit would be expired. That we've also mentioned specifically in our paper, but due to the time constraint, we could not elaborate on that in our presentation. But definitely, ma'am, your suggestion has already been incorporated in our paper, as well as the 2019 draft law, which tries to clear the confusion. If that is enacted, we believe that that would complement the 2020 Act and ensure proper virtual courts, and in the long run, any judiciary or what you remarkably prescribed digital judiciary of Bangladesh. That's a very interesting concept, ma'am, and I really look forward to hearing more from you as well on that matter. And thank you, ma'am, and thank you to distinguished guests and panelists, and specifically ma'am and Iqtida sir for their informed recommendations on our paper. We'll definitely keep this in mind. Thank you so much.
Thank you so much, Mashraf. Thank you.
Okay, we are in the last part of our session. This is the question and answering session. I am requesting the audience, if you have any question, you can ask question to the paper presenters. Any questions? No questions from audience.
Asad, this should not be done. At least ask a question. All the time I ask question, yes, in all session previously held. Even today, I didn't take much preparation for my session. In the morning session, I was there from the initiation to the end. So here you showed us. Yesterday I asked so many questions.
Okay, I will ask. I think there is Farhana madam is also with us. Dr. Farhana, would you like to ask any question or any comments or observation to our paper presenter? Then I will ask some question. Dr. Farhana Mehtab.
Assalamu alaikum. No, there was no such observation, but I want to appreciate University of Asia Pacific. Walaikum assalam. Jamila, I mean, you did wonderful job. I was really appreciating the way you were commenting on all the topics, all the papers. Much appreciated. Thank you so much. Thank you, the organizers. We just love it. Thank you.
Thank you, Abba.
And probably Shupang sir is also with us. Sir, would you like to make any comments?
Asad is shifting his burden to one of 10.
No. I'll not shift.
Today you have to ask a question.
Okay, I will obviously ask a question. Okay.
So, yes, just a bit of note. It's to Ali Mashraf and Jalaluddin Ahmed. I was just rushing through your abstract. I was wondering whether you were reflecting on some sort of
procedural issues that our virtual courts are undertaking to have digital evidence. Because when the Law Commission, they were trying to draft a law on virtual court system, I was invited there. And one particular issue was how to entertain different sorts of evidences. And one burning issue was how to differentiate between digital and virtual evidence. Since there are many retired judges there and some acting judges, since they didn't have any knowledge, particularly on digital format or type, whatever you may call it, they did not have any clear ideas on those issues. Then the draft that was prepared that came to me, and at some point I noticed they failed to differentiate between those two things. One is virtual evidence and another one is digital evidence. Do you have any mention in your paper, this sort of thing? Because I think it's a very important issue whenever you are trying to give access to justice for the people, especially people in the remote areas. It's not a note, it's actually a query from me to the authors.
Thank you so much, sir. Sir, definitely,
thank you, sir. My point, okay, alias Ashraf, please.
Sir, no, sir, you may go ahead, sir. No problem, sir.
My one point is that virtual court and digitalization, one of the great concern is that cyber security is a great concern. On the other hand, there is a right to privacy is also a great concern. Because through this virtual court and digitalization of court, privacy is, since all kind of litigation, there might have something we have to keep in privately, or there should have a privacy issue, unless and until verdict is pronouncement. But during the course of time, because of this forum, because of using Zoom on other media, there is a great threat or concern of privacy. We should look into it. Number one. Number two, cyber security is a great challenge all over the world now. So what happens if there is any hacking or if there is any cyber threat to our all system and judiciary? Then we have to keep it very seriously. That cyber security must be ensured with maximum caution. Number one. Number two is online education. Yes, online education has become inevitable because of this COVID-19 situation. There are some problem behind the online education. We need some policy framework on online education, but in course of time, now we are looking for hybrid time of mode of education. That is physical education as well as online education after the COVID-19 situation. I think the researchers should look into it, whether this would be feasible, good thing, or this would have any other problem to continue online education along with campus mode education. Another point is role of COVID-19 and our international education. At one of the panelists rightly says, this is very wider in sense, but if we think any particular topic of international, that would be nice, I think. They should be more careful. Then their paper will be more accurate and very specific and precise. They will look into it. So thank you.
Thank you, sir.
Sir, I had Shrupan sir asked us a query. So before that, Asad sir, thank you so much for your timely recommendation on our paper. And yes, privacy issue has been dealt extensively in our paper as well. And we have also provided some of the recommendations based on Mr. Barrister Ajmal Hussain QC sir, who also is now practicing in Singapore courts as well as UK courts. And he has given us some examples of how cybersecurity is maintained in UK courts as well. So our recommendations were based on those practices as well as other practices that we showed in our slide. And it's extensively dealt with in our paper. To answer Shrupan sir's question in a nutshell, yes, sir, our draft 2019 Act in section 4 asks about validity of electronic records, and in section 12 talks about procedure to prove documents digitally. However, sir, as you mentioned, the differentiation has not been made, and we on the other hand have actually proposed that the 2019 law should be amended and at the same time be enacted to complement the provisions of the 2020 Act, which does not have any procedural provision. But you have aptly pointed it out, sir. Those lacuna we have already mentioned, they need to be fulfilled. Thank you, sir.
Okay, thank you, Master. I can't take any more questions. we have a shortage of time. Here we are ending our session. Our next session will start at 5 p.m. I request you all to join. Thanks again to the panelists, participants, and audiences. Stay safe and stay at home. We will win COVID-19, inshallah.
Inshallah.
Thank you.
Okay,
Thank you, everyone.
Thank you, everyone.
Recording stopped.